Andrew, there's so much to say about this, including how the Supreme Court forced the rewriting of this indictment. And what do you see as the likely way Jack Smith has tried to thread the needle to get this to trial?
Yeah. So one piece of interesting news to sort of pick up on your opening, which is if for people who are counting, this now makes 5 grand juries that have decided that Donald Trump is guilty of, by probable cause, of multiple felonies. So this is the 5th time that he has been charged criminally. Because this is a
start, by the way, with why this had to be a new grand jury hearing all of this for the first time.
Yeah, so that's a great point, because that really goes to the question of why now? Why was Jack Smith doing this? Like, what does he gain from this? One of the things that I think he gains is really taking an argument off the table and trying to say, you know, Donald Trump can't challenge the old indictment by saying the grand jury that charged that didn't know what the law was, that it somehow was tainted by evidence that the Supreme Court has now said it shouldn't hear. And so there may not have been a lot of merit to that argument, but this just removes that issue about whether there needed to be a new indictment, because now there is one. It's a relatively simple process to represent a case. They clearly did that. And so it just, I think, will streamline the sort of arguments that are going to come, both at the district court level and up to and including back to the Supreme Court. So this is all an issue if Kamala Harris wins. Otherwise, this is all irrelevant because Donald Trump will get rid of this in a nanosecond.
So what does this do to the schedule in Judge Chutkan's courtroom? We were anticipating a possible hearing or at least argument about what should be allowed in this case. Has this rewritten indictment, in effect, is this become Jack Smith's argument about this is what the charges should be?
Yeah, I mean, you know, I had anticipated that he could have done this without superseding. He could have just said, you know, we are not going to proceed on the following allegations. But this is definitely a cleaner way to do it. Donald Trump, as is his wont, and frankly, as a defendant, is entitled to raise any and all arguments about. He will certainly say there should not be a hearing on this until after the election. We will know on Friday whether Jack Smith says, no, we should have argument and hearings about proceeding on this case before the election. There's no way it will go to trial, but you could have a lot of issues decided because the key thing that happens in terms of what's added and what's subtracted. What's subtracted, as you noted, is all of the allegations about the Department of Justice and internal White House actions are sort of deleted from this. What's added is lots and lots of language saying that Pence acted as either a candidate or as president of the Senate. In other words, not as an official piece of action. And that Trump was acting also in an unofficial way. Well, Donald Trump can say, I challenge that. I think that's not right. And you could then have a factual hearing. Now, of course, that's the last thing that Donald Trump wants, is he does not want a factual hearing, at least before the election, because that would lead to people like Mike Pence being able to take the stand and testify that he, in fact, was acting as a candidate, or he was acting as, as the president of the Senate. That, I think, is going to be the battleground, and it'll be interesting to see whether the sort of reports that Jack Smith may not be seeking that kind of hearing before the election, whether that's true or not. It's not totally clear. We haven't really heard from the horse's mouth. We have really only heard sort of leaks that presumably are coming from the defense side. And on Friday, we should know whether there will be that type of hearing, which, of course, could be really explosive because of course, Mike Pence's position and what he has said in the grand jury to Jack Smith is not public.
So one kind of basic interpretation of the Supreme Court immunity invention is that the president, when he's ordering people in the executive branch who he can boss around, whatever he's doing there, he's immune from crimes. That's a sort of quick, dirty way of saying it. The trouble with the vice president is he is under no obligation at any moment to obey anything the president ever says to him. He's independently elected, and he occupies an independent constitutional office. He need not ever speak to or listen to the President of the United States. And so this dynamic with Jeffrey Clark and Justice Department officials that may have gotten that scene knocked out of the indictment doesn't seem to have any impact on a very similar scene of Donald Trump talking to Mike Pence, trying to get him to overturn the election.
I think what Donald Trump would argue on that point is that is true. What you are saying about the vice president's independent function is true. But when Donald Trump is acting as president in trying to convince his vice president to do something, as long as he is acting in an official capacity, the Supreme Court has decided that that would, at the very least, be presumptively immune. And if it's within his core powers, it's absolutely immune. Just to be clear, I think that is, to use a technical term, bonkers.
Right.
I mean, that is just an outrageous decision.
Right.
Ketanji Brown Jackson was unbelievably polite in the clip that you played in terms of what this means for the country. The idea that, just to be sure everyone understands, the Supreme Court said, even though that Donald Trump is alleged in the prior indictment to have sought sham criminal investigations of his opponents, he is absolutely immune to do that. That is the Supreme Court decision. Sham DOJ investigations, absolutely immune, because that is considered by the Supreme Court a core presidential function, is seeking sham investigations. Just to say it is really to refute it.
Yeah. So what do you see as a timetable here in this case now?
So I think that Judge Chutkan has her work cut out for her if she wants to have a factual hearing with evidence before the general election. On the other hand, that is, in large part, one of the things that the Supreme Court decision said she needs to do. At least on some of these areas, they said there are factual issues that she needs to decide. So she could decide that she's going to go forward. You know, the issue will be whether she's sort of helped by Jack Smith's position on Friday, where Jack Smith says, yes, I'm willing to do that, or whether Jack Smith says, no, let's do this after the general election.
And so as it goes forward and as Judge Chutkan decides through one process or the other, what she's allowing to go forward, the Trump lawyer is going to just get up and make a motion to dismiss pretty much everything in the indictment, saying Supreme Court immunity. She's going to say no, and then they're going to appeal it up again to the Supreme Court.
Yes, but it'll be hard for them to appeal it prior to that factual hearing.
Yes.
There's no question that they can delay the ultimate trial. Again, if Kamala Harris wins, they will definitely be going back to the Supreme Court for an additional ruling. So this could take a lot of time. But the one way I look at this is, if Donald Trump wins, we know this is absolutely gone. If Kamala Harris wins, at least there's a chance it will go forward. It just may take some time. But that hearing, where you will hear additional evidence and there will be new material for the public to digest about Donald Trump and what he was up to, so it's something for us to go on in terms of what he did, that is something that should happen prior to any potential appeal.